Hi guys, this is Erica from Gokce Capital. Now before I begin, be sure to click subscribe and turn on the notification bell. When John Ragner purchased his Flagstaff home in 2006, he became a homeowner at just 29. The house was a stretch, but he planned to construct and rent out a carriage house in the backyard to help cover his mortgage. Yet 10 months after John moved in, the city upended his plans. So what happens when zoning revisions affect your ability to afford your mortgage? We'll find out at the end of this video. But first, we're going to dive into the differences between a deed of trust and a mortgage with 7 things you need to know. Number 1, what is a deed of trust? In some states, a deed of trust will be used instead of a mortgage when a purchaser buys a property using borrowed funds. This document indicates that the property buyer will repay the loan, and the mortgage lender will hold the legal title to the property until the loan is fully paid. Number 2, so how does a deed of trust work? In exchange for a loan, the borrower provides the lender with one or more promissory notes. A promissory note is a document that states a promise to pay the debt. It is signed by the borrower and contains the terms of the loan. Once the borrower purchases the property, they will transfer legal title to a neutral third party who holds title on the lender's behalf as collateral for the loan. This is done through a deed of trust. When the loan is completely paid, the promissory note is marked paid in full, and a deed of reconveyance will be recorded, returning legal title to the borrower. Number 3, there are 3 parties in a deed of trust. These include the beneficiary, or the company or person whose investment interest is being protected. Often this is the lender, but in the case of owner financing, it could be the owner of the property. There is also a trustee. The trustee holds the legal title while payments are being made. They're supposed to be impartial and should not do anything that unduly benefits either party. Often the trustee is the title company. And finally, there is the trustor. This is you as the borrower, or the individual whose assets are being placed into the trust. Number 4, what is a mortgage? A mortgage is an agreement between a borrower and a lender that gives the lender the right to take the property if you fail to repay the money you've borrowed. As with a deed of trust, once you take out a loan, you will sign a promissory note at the closing, also sometimes called a mortgage note. But the note will be secured with a mortgage deed rather than a deed of trust. The key difference is that a mortgage does not transfer legal title to a trustee, but rather places a lien on the property. Number 5, what are the similarities between a deed of trust and mortgage? First, neither a deed of trust nor a mortgage is a loan. A loan is something that you agree to pay back to your lender, and its terms are usually outlined in a promissory note. Instead, both a deed of trust and a mortgage are contracts that allow a lender to sell or take the property if you default on the loan. So in other words, both a deed of trust and a mortgage provide a way for a lender to repossess a property through foreclosure. And finally, both deeds of trust and mortgages are dictated by state laws. Most states stipulate that lenders must use one or the other, although a few states, like Alabama and Michigan, allow both. Number 6, what are the differences between a deed of trust and a mortgage? These 2 documents are very similar, but they do have some key differences, including the type of foreclosure used. If you have a deed of trust, you'll typically face a non-judicial foreclosure. Because legal title is held by the trustee, a lender does not necessarily need to go through the courts to foreclose on the property. On the other hand, for a mortgage, the lender will need to do so. Because of this, the foreclosure length and expense varies depending on whether a deed of trust or mortgage is used. With a mortgage, your lender will need to seek a judicial foreclosure, meaning the mortgage will take more time and money to foreclose upon. As a result, many lenders prefer deeds of trust if the state allows it. In addition, the number of parties involved differs between the 2 types of contracts. A mortgage involves just 2 parties, the borrower and the lender, but a deed of trust, as we discussed before, has 3. And finally, how does the deed of trust or mortgage impact how you hold title? With a mortgage, you as the borrower continue to hold legal and equitable title. And if you're not familiar with these terms, the legal title holder is the person who is technically considered the owner of the property. On the other hand, the equitable title holder has the right to use and control the property. So again, a mortgage is essentially just a lien on the property. It does not involve an ownership transfer. On the other hand, with a deed of trust, legal title is transferred to the trustee. However, you still hold equitable title. So in both cases, from a use perspective, you're the owner and can live on the property or improve it. But let's return to the story of John Ragner. In 2006, John bought a small house in Flagstaff's oldest neighborhood. Prices had recently skyrocketed, and the $380,000 price tag was out of reach on a firefighter's salary. So John took out an interest-only loan to cover the initial purchase. His plan was to transform the property's existing backyard carriage house into a duplex, rent out one unit, and then refinance his mortgage. All of this was acceptable under current zoning rules. But unbeknownst to John, a revolution was underway. 10 months after John purchased the home, the city established a historic district overlay for the area, imposing a height limitation of 16 feet for all new accessory buildings. Just like that, John's planned duplex was dead, and without it, John could not afford to stay. Fortunately for John, the historic overlay was not the only new voter-led land use regulation enacted at the time. Arizona had just passed a statewide initiative, Proposition 207, which gave property owners the right to demand compensation if a new regulation reduces the value of their property. John thus filed a claim against the city alleging that the new historic district devalued his property by $168,000. The city refused to pay and would later argue that there was no way to prove the new overlay diminished property values, especially because historic districts often raise home prices. But of course, the issue for John was that he could not afford his current mortgage, and so, along with 3 other homeowners, he took the city to court in a case that would use Proposition 207 to determine which has supremacy within Arizona: an individual's right to make development plans without concern for future land use changes, or a city and community's right to regulate growth. In the end, John's case didn't answer this question, for it was thrown out on a technicality, leaving future cases to hash out how cities and neighborhoods within Arizona should balance the competing interests of current and incoming residents, especially as home prices continue to rise. Now, do you have any interesting stories about mortgages, deeds of trust, or even land use? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down listings at gokcecapital.com/listings. Finally, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.